But we're all aware that there's a day you were born and there's a day you will leave this place. And obviously, as Christians, it ushers us into a place that we all look forward to going to. But we tend to leave this place, correct me if I'm wrong, stand up in protest, but we tend to leave this place reluctantly. And so, let me ask you a question. How many of you are ready to leave this place? Don't answer. Don't answer. But how many of you are actually ready to leave this place? This is our reality. This is what we know. We've made friends. And so, leaving this place, I think, is a challenge. But imagine those of you who come to church, every time you come to church, one of the key messages is to prepare yourself for, isn't it? And so, even as we prepare ourselves for what comes after this, those we leave behind, do we prepare them for when we leave? And I think that's why we're here. And so, thank you for coming. I was wandering around and I was really excited to see some really young people in our midst. And I just shared with a young man called Philip. And we were talking about, why is he here? And Philip and a few other young people, these two young ladies, were saying, knowledge is useful. It's good to know ahead of time. And I shared that it's also good to know so that you can help those who are ahead of you also. I think sometimes the Gokas and the Shoshos probably struggle even more when they're the traditional, or the traditional mold. And so, without much more ado, let me just run you through the program for the day. We're going to have two presentations, two keynote presentations. One by Chief Justice Martha Koome. It's rare to get an opportunity to ask a sitting Chief Justice a question. But I want to take advantage of the fact that I have the microphone. And I want to ask this question, because I've seen confusion on this matter. Is it Madam Chief Justice? Or is it Lady Chief Justice? Or like I saw in Citizen, is it Honorable Chief Justice? And the last version I've seen is Honorable Madam Chief Justice. So I'd just like to ask, what is it?
When I'm here, just call me Martha.
Okay, you heard it. Just call her Martha for now. Yeah? All right. So, by way of introduction, I'll introduce her before she goes up. But what we're going to do is we're going to have those two keynotes, and then I think you saw in the adverts, we're then going to break out. And I'll tell you a bit more about how that breakout works. But in that breakout session, in the breakout sessions, we'll have 5 groups, and each one of you have the choice of attending 2 of those groups. And then at the end, we'll summarize those groups so that even those groups you didn't go to, you'll get to hear what it was about in summary. Our keynote will be on the law of succession in a patriarchal society. And that marries very well with one of the breakouts, which is the rights of surviving spouses. Our second keynote will be on wills, benefits, and challenges. And I'll introduce that when we get to it. I'll also talk about the 5 subjects just before we go into those subjects. So allow me to introduce our keynote speaker. And I think I have some surprises for her here. So. You asked me to MC, so here we go. I did a bit of research on this, and it is written. And you have been aware. On April 27th, a local paper wrote, and I quote, "Martha Koome is an academic genius with an LLM in Public International Law from the University of London in 2010. Having earlier attained an LLB from the University of Nairobi in 1986. She set up her private legal practice in 1988, joined the judiciary in 2003, and practiced across various stations all over this country, during which time she also served as a council member of the Law Society of Kenya. I personally, and my Hekima colleagues, have not experienced a process followed any closer than when the JSC, Judicial Service Commission, announced one Tuesday the nomination of then Court of Appeal Judge Lady Justice Koome for appointment as the country's next Chief Justice to replace retiring CJ David Maraga. The media narrative became, if appointed, she will become Kenya's first female Chief Justice. And on May 19, as they say, this became history. So I'd like you to join me in congratulating our very own Martha Koome on her recent appointment. Congratulations, Nkaribu. The other thing that caught my eye as all this was happening, and I think a lot of the church members here were really in prayer. And so we thank God for the outcome. Another thing that really caught my eye was that Martha Koome comes from a very supportive family. I think it was an auntie in Meru who was saying just how tight-knit the family is. She has a loving husband, children who we know, and many relatives. She and her immediate family are long-standing members and much-loved members of this family, Karura Community Chapel. And so I'd like to invite Martha, she's given me permission to call her that, to present her bit on the law of succession in a patriarchal society. Help me welcome her on stage. Yes.
Thank you very much, my brother Job Oduor, for that introduction. Good morning, everybody. Thank you, Mara, for organizing this. I think we should appreciate Mara. Mara is our convener, a group called Hekima. Previously, we used to call ourselves Over 45 Years, and I think some people were embarrassed to be associated with Over 45, and therefore we transitioned or transformed ourselves into the name Hekima. So this is the group that has organized this event. This event was supposed to take place last year, but because of the devastating effects of the COVID-19 global pandemic, we could not hold it last year. God's timing is always the best. We could never have envisaged that this year, almost the same time, I will be the Chief Justice of the Republic of Kenya and the President of the Supreme Court of Kenya and the head of one arm of the government. This is completely because of the grace of God. And I want to thank Karura Community Chapel in a very, very special way. I want to thank the many groups that joined in prayer to pray for me as I walked this journey. It wasn't easy, but through the power of prayer, I have a big testimony to give that the grace of God prevails upon us all the time. And it hovered over me throughout that grueling interviews that I went through before the JESC and before the Parliament, and up to where I am today. I continue to see the hand of the Lord every day in all the things that are happening since I took the office of the Chief Justice. So thank you very much. All of you congratulated me, wished me well, gave me very, very kind words of encouragement and of support. I do not take it for granted, but I really felt that I belonged to a family. This family walked me all the way to State House to swear. We were with Pastor Shiramba, and he also prayed for me during the day that I assumed office. Today, I'm honored, and indeed it is an awesome joy for me to participate in this forum. It's a forum that is so dear to us, to me also, as a judge and even as the Chief Justice. And I'm so privileged to share the forum with very eminent lawyers, members of my profession, the legal profession, Advocate Rea Kigwatha. Thank you very much for agreeing to come. We had occasion to deliver this same seminar, not in such detail, but to the congregation of the Women Fellowship. And I was asked, why are we only speaking to women? And for the very same reason that today I've been asked to speak about patriarchy and the law of succession, that is why we were speaking to women, because they find themselves, or we find ourselves, to be the victim of the patriarchal structure of our society. Therefore, it is important for women to be empowered with information on how they can avoid the pitfalls that bring a lot of conflict, uncertainties in their lives. So even if I'm asked to repeat again a session to speak to women, I will, not only here, but anywhere else, because they tend to be owning the shorter part of the stick, as this lecture will reveal. I'm also very happy to participate here with our very own lawyers in this house, Advocate Tony Jogona, Jerry Kariuki, a senior lawyer, Jane Mwangi, Rosemary Muhoro, and Muhoro Kimani. The last three, we have a very, very special relationship with them because we were classmates. This was a class of left university in 1986 and the Kenya School of Law 1987. We share a very special bond, and I'm happy to share this forum with you, my brothers and sisters. So without much ado, why are we speaking about patriarchy in Kenya today when we have the Constitution of Kenya 2010 and we also have the law of succession that actually recognizes both gender. The Constitution of Kenya outlaws discrimination completely. It is awash with principles of equity, principles of equality, principles of fairness. So why would a woman be discriminated today? This is deep. And it is deep because it goes into our culture. First of all, when we were colonized, we lived under that patriarchal system of society that did not recognize women as ends of a family or people who could give leadership in the family. So the law of succession that we used then was scattered all over, and it was basically not codified, even for us to understand what was the African customary law. So after a lot of work was done by a commission that went around the country, it came up with the law of succession, Cap 160, which is a branch of the law that deals with inheritance and regulates the transfer or passing of ownership of property rights when a deceased person has died. And, inheritance is found in scriptures. It is provided for in Proverbs 19:14. House and wealth are an inheritance from fathers. You hear, fathers? A good person leaves an inheritance for their children's children. So, this finds place in our African culture, and it was unheard in that society that a woman would make a decision on how the property of the family would be inherited. Decisions, of course, were made by men. Just as it was in Numbers, chapter 27 and 7, we found that women were complaining. The patriarchal system that was displayed in Numbers 27, where the daughters of Zelophehad, who belonged to the clan of Manasseh, approached Moses, Eleazar the priest, and other leaders to petition for their father's land to be given to them. This was because their father had died without a son, and this portion would otherwise have been lost to the brothers. In response to that request, God himself spoke to Moses in Numbers 27:7 and said this: "What Zelophehad's daughters are saying is right. You must certainly give them property as an inheritance among their father's relatives and give their father's inheritance to them. Say to the Israelites, if a man dies and leaves no son, give his inheritance to the daughter. If he has no daughter, give his inheritance to the brothers. If he has no brothers, give his inheritance to the father's brothers. If his father had no brothers, give the inheritance to the nearest relative in his clan, and that he may possess it." This is to have force of law for the Israelites as the Lord commanded Moses. If we read this scripture to a clip that was shown in the Nation TV, I think a few days ago, where we saw a woman who was a widow with her daughter being kicked out of the family land simply because she did not have sons, that would never have happened. That woman would never have been thrown out of her home. It doesn't matter whether it was ancestral land. When her husband died, whatever belonged to the husband, should have belonged to her. So why is it happening in Kenya? We are a country which is 80% Christian, and we also have a constitution, and we have the law of succession. So this is why it is important for us to keep talking in these seminars, to educate our people, to pass information so that they can be empowered to know their rights and to know how they can claim their rights. Because the customary law, which is also fed by greed, has taken a great hold of our society. The law of succession has been with us for quite a while, from July 1981, when it came into force. And it applies to all matters of a person who has died from 1981. The Act itself, if you may ask me, is very progressive, and it is geared towards remedying the discriminatory nature of our customary law as pertaining to the right to inheritance. This is a law which has been in place since 1981. You know how we worked hard as a Kenya, as a country, to review and reform our own constitution. Some of these very progressive provisions in the law of succession were hindered by that old constitution that we had, because the old constitution, specifically section 82, outlawed discrimination, but it allowed the practice of customary law when it comes to determination of family matters. And of course, succession is family matters. So that is why we continued suffering, making one step forward, another step backwards, because some people would argue this is personal matter. The Constitution allows me to practice customary matters to determine personal matters. And these personal matters just happen to be matters that touch on women. Personal matters are about divorce, they are about maintenance of children, they are about custody of children, they are about inheritance. And this is why women were on the forefront fighting for non-discrimination, that it should be anchored in the Constitution, and anything that gives differential treatment on the basis of gender or on the basis of marital status is against the Constitution. Ultimately, we have the celebrated Article 27 of the Constitution, which provides, and I quote, "Women and men have the rights to equal treatment, including the rights to equal opportunities in political, economic, cultural, and social spheres." Women, can you say amen? Amen. You are protected by the Constitution, Article 27, and also 40 recognizes and protects the right of every person to acquire property regardless of sex. And you can acquire this property anyhow. You can inherit it, you can get it as matrimonial property, you can buy it, you have all these rights protected. And the Kenyan courts have proclaimed these rights in very, very profound way in many, many judgments that have been pronounced to say that you cannot discriminate when it comes to inheritance on the basis of one's sex. And I've had occasion also to sit in these matters as a judge in the High Court, and the question they would ask me is, why would you give a daughter a share of the estate of her father and she will get married? when she gets married, she will also inherit from where she got married. And I would just refer them, even before we got the Constitution of Kenya 2010, I would refer them to the law of succession that does not discriminate on the basis of status or on the basis of gender. And say, for me, it doesn't matter. And even the Bible tells us, and even Jesus proclaimed it, there is no Jew or who? Gentile. So when you have children in your home, there is none that you carried with the stomach and another one you carried with the back, isn't it? There is no Jew or there is no Gentile, isn't it? So why would I, as a judge, treat them differently? Bring other principles that are not known in the scripture or in the Constitution or in the law of succession to treat a girl differently from the boy. So me, I used to give them a very simple reason. I used to ask them, is the boy also married? And the answer would be yes. The boy is married, and the girl is married. Is the boy married to a stranger? Yes. Is the girl married to a stranger? Yes. So I would say in your home, you have those strangers, you just have to deal with them, but you have to deal with them equally. If where the girl is married, she happens to inherit, well and good. If the man she is married, if the boy has married a girl who happens to inherit, that is her property, isn't it? And you just know how to deal with the property. It's not a problem. So this is the scenario we have today. Our law, as it is good, but it's implemented by us who carry our baggage, because as we determine these cases, sometimes we look at our own situation and start asking questions and applying it as if it is our own situation that is before us. But what I assure people is that the beginning point is for us to empower ourselves with information. Because the other thing I've learned in this practice of many years is in this country we have a big disconnect between the law, the practice, and the knowledge. We pass laws to protect people, to empower people, but they hardly get to know what is in that law. So that if today you are believed, and I've seen very many painful cases of people who are believed, and they are completely lost. So the simple procedure, because when I sat in the family division, the first thing we did after I saw the avalanche of people who are coming there in so much pain and frustration was they did not know the procedure. Today you come to court, they tell you go and bring us a letter from the chief. And the letter from the chief is important because when you sit in court, you don't know who is who. It is the chief who introduces the family of the deceased to the court. The chief writes a letter to say so and so died as per this death certificate and comes from my area. And I know he had a wife and the children, assist them. So the first thing we did was to have information passed to the chief's barazas through the DOs that chiefs have a very important role to play by giving us this information. And should they misread the court so that the court gives the letters of administration to the wrong people, they will suffer consequences. And I think today I can proudly say no chief will be willing to mislead the court by giving the wrong information. The next thing you bring, of course, is that death certificate. Many people don't even remember to pick it when they are bereaved. Of course, they are very, very overwhelmed with grief, so they may never even remember to go for the death certificate. And of course, the list of the estate that the deceased left. We would like to have a search done at the lands office so that you don't also bring property that did not belong to the deceased or property that belonged to other people, and we issue the grant on the wrong property. So the first thing we did was to prepare a checklist. Once somebody dies, please bring us these documents. Complete with even the amount of money you pay to the government printers for them to announce that application for the letters of administration in the Kenyan Gazette, because that's how we announce it. So the law is also very clear on who should inherit the estate of the deceased. And I dare say it is exactly what is stated in the book of Numbers 27:7. And this is why we should be reading the Bible, because I think it assists us also to sort out our own personal problems. Section 66 of the Law of Succession tells us how and who has the priority when the deceased has died. If a person has died and has left a spouse and children, the law tells us, Section 35 tells us, how that estate should be divided. First of all, who has the priority to be given the letters of administration? The husband dies, it is the wife. If the wife is not there, it is the children. If he had no children, it is the parents. If he had no parents, you go down like that with that priority until you reach the last. If he had nobody, then the government takes over. Or if he had nobody but he had creditors, creditors can take over. But when somebody dies and leaves a wife, sometimes she is looked down upon. This one, she is so old. She is illiterate. She is sick. You know, so I would get applications like that when I sat in the family division, and the husband died, and the widow came to court to apply for the letters of administration. So the children would gang up, especially, usually I saw this from the male children, coming to say, no, you can't give this one, because they are suspecting she may, give it to the daughters or misuse it or just not do the way they want it to be done. And they would use all manner of adjectives to describe their mother. And I would just look at them and ask them, is this your mother? They would say, yes, it's our mother, but she is old, she is illiterate, she is sick, she cannot be able to handle this. Then all I would do is read for them Section 35 of the Law of Succession and Section 66 and tell them, unfortunately, this is your mother, and this is what the law says. When your father dies, she has the priority to take the letters of administration and to own the whole property for life as she is enjoying the life interests. In other words, these buildings you're talking about, she is the one who is entitled to rent. She is the one entitled to hold it for you in trust. When she dies, then you will inherit it, all of you, equally, all the children. So this is the law, brothers and sisters. Why is it not being followed? The problem we have is greed, coupled with lack of information. Number 3, coupled with lack of access to justice. And this is why I'm standing here proudly as the Chief Justice to say that it is my business to bridge this gap between the people and access to justice. Can you say amen to that? We should not be subjected to a process that subjects us to frustrations of delay, frustrations of expense, frustrations of accessing the court where it is. It is the business of the government to make sure that justice is accessible to people, that they do not have to travel long distances, and when they travel there, they do not have to be told, come tomorrow, come the day after, come this, come this, come this. They ought to be given services expeditiously. And this is why I applied for the position of the Chief Justice. And I want to repeat it here, that I did it because one thing that really annoyed me is the delay it takes when somebody comes to court. When you enter that process of the court, you don't know. You can never predict for how long you are going to be in court. We have seen estates come to court and stay there for 10, 20, even 30 years. Some of them, I found them before I became a judge. I've been there 33 years, and they are still there. Ask me what they are doing. For me, the estate, it doesn't matter how big it is, even if it is from here to where, or if it's just a simple peasant who has died like my father died, the law is the same. What you're supposed to do is report like you did. Then so and so died leaving these properties. So and so died leaving this number of children. So and so died leaving this number of wives. Because we also have a provision of the law that deals with an estate where the deceased and many spouses. This is the reality of our society. There are people with many spouses, and the law recognizes them. So I'm told delay comes when there is objection that this was not a child of the deceased, and this was not the wife of the deceased. And I had occasion to settle many like those. So who was the wife? There is this wife who has a marriage certificate. We recognize her. But he went around, the deceased, and married another. So there was also another one. He was paying school fees for the children, I don't know, buying bread, and I don't know, paying rent, and I don't know what, and they have all come to say now they are wives of the deceased, and they are now entitled to be provided for in the estate of the deceased. And indeed, they are human beings. They are people with rights. And for us who are also constitutional law practitioners, we know something called legitimate expectation. If a man has come and has been providing for you, he has been paying school fees for your children, he has been paying your rent, you've been posting around there, there is something called legitimate expectation that once he dies, I will continue with this kind of life. So they come armed with constitutional provisions and all that. But what I'm trying to say is that there are processes in the law for trial to ensure that people do not also take advantage, undue advantage of the estate to harvest where they did not plant. So these days, we have progressed. We have looked at the first wife. What did she acquire with the deceased? And pronouncements have been made. If this wife married the deceased in 1960, they acquired this. And then in 1980, he decides, now you can marry another one, who comes and has children. The old law would have said that they are all counted as the same. This one who got married in 1960, this one who married in 1980, and their child who was born in that years later will share the same as this woman who got married in 1960. That was a law before the Constitution 2010. But now, there are decisions that say we have to take equity into account, we have to take fairness into account, and this woman who got married up to 1980, that property which was acquired, must be divided equally between her and the deceased. Then what was the share of the deceased is what will go on now to be divided amongst the newcomers who have come into the scene. So the law is progressive. The law also grows with our society as it is, because the law recognizes, like children who are born out of wedlock, they are children of the deceased. If you can prove that they are children of the deceased, they are entitled to the estate of the deceased, because this is the complexity of our society. We always advise people to live narrow and straight, to avoid messing other people around. Going to get children, if you get children, you have to bear parental responsibility for those children, and that is the law, even according to the Children Act, that the parent bears the responsibility of children born out of wedlock. So what complicates the situation for women is, and that this does not happen to men, of course, because I have not found a woman who has died and their husbands who are coming to claim. We are yet to see that. So gentlemen, this is why we were speaking to ladies, because really they are disadvantaged. So you find a wives, former wives, all of them being spoken to by the law. And therefore, it is important for us to empower these women with information to know when am I a wife? When am I being counted as if I'm wives? And when am I a former wife? And when am I coming now if I became a former wife? At what stage do I come? And what do I claim as a former wife? And what happened to me when I left, I became a former wife? Did I remarry? Did I, forget the interest that I had in the former relationship? So, these are the complexities of our society. But thanks be to God, because we have this very progressive constitution that entrenches the values in the Bible, values about fairness, non-discrimination, and treating everybody as an individual who has rights and who has inherent rights that cannot be taken away. So my sister, Rhea Kegwetha, will be speaking about the writing of wills. Usually when we delivered this talk, my speaking is usually random because it cuts across experience, it cuts across what is in the law, it cuts across the practical approaches that we have made to solve these problems, but mainly on information, so that we can be able to arrange and see our lives when we are no longer there. When we are no longer there, how would we like our affairs handled? We, first of all, need to know who we are, what we have, and how we would like the matters handled. So we need to empower the people we live with information of what it is that we have. And we need to own that information, because many people have come to court and they keep coming. Oh, when we came, we didn't know deceased owned this property, or review the grant that was given so that we can hand. So the biggest problem we have is, people don't even consolidate, what it is that they own. and put it together. So you leave, the people you leave, sometimes they may never even discover those properties because, they are all over the place. So people are advised to write a will. And if you have children who are born out of wedlock, they are your children. They are your responsibility. And if you have been having these other spouses, I don't know whether they are spouses, mistresses, or whatever name they may be called, please make some arrangements, enter some contracts, enter some arrangements with them so that you can be able to secure your family, to protect your family from other people who will come and harvest where they did not plant. And it happens a lot. And when they come to court, this is another reason why I'm giving this seminar, and I will not tire to give seminars. We like people to teach or to take agency of their lives. Take full responsibility of your life. And this is why we are advising people, you don't even need to go to court other than for the administrative bit that I need this certificate of confirmation of grant because this is what I will use to transfer the property. But when it comes to settling disputes within families, my honest advice is that we try to mediate and speak and talk to one another and communicate with one another. I can never for the life of me understand why a family, brothers, sisters, mother, father, uncle can troop to court to go to tell a magistrate to determine this dispute for us. Is it nice? It's not nice. We can be able to talk to each other. We can be able to listen to one another. And if we cannot, we can come to church, a place like this, or another forum where we feel comfortable, and ask our elder like Job or Duo. Even Mahara, she doesn't understand our customs, but she understands the Bible. She understands the Constitution. Our pastors, they can be able to guide us how we can resolve these matters. And if it can't happen there, we also have what we call now the court annex mediation. They can assist us just to talk, because the problem is people stop talking to one another. I don't know why people stop talking to one another. And because I do this a lot, I even speak to couples who are getting married. What I advise them is never stop talking to one another. Oh, they say, oh, but she talks a lot, or, it doesn't matter. Talk. All right? Until we can listen together and resolve these matters. Because the lawyers here will tell you, these estates you see, it is the lawyers, the professionals, I don't know, accountants, brokers, auctioneers, who eat it all. It is not the beneficiaries. So if you want to protect your estate, empower yourself with information, take the agency of resolving your own disputes, because who else knows what is your best interest other than yourself, isn't it? They come, they tell us, oh, our father left this property. We cannot agree on how to share. Us, we don't know who has built where and done what year and done what year. So when we say equal sharing, give us a valuation, give us a survey, where you are built may end up with the other person's, it may end up being in the other person's side. And if this is the schedule of subdivision that we have been brought by the experts, we adopt it. Then it ends up that you are being removed from where you are built, where you have done what, really messing people around. There is nothing wrong we have done as a court because we have shared it equally. But it is you, the owners, who are in the place, who should know the best way that we do not have to disturb anybody. But because people are fighting, because people never speak, because, I have already threatened you, tutakutana kotini, so this is why the court must be the one to determine, and then keeps the family permanently in conflict. Because even when the judge is the one who is deciding, there isn't much happiness and harmony. But when you do it yourselves, when the mediator does it, you greet each other and you go home peacefully because you are the ones who found solutions to your own problems. So this is why I'm saying my vision of the administration of justice is a top-down approach, a bottom-up approach that comes from, resolutions come from the people themselves. People take the agency of understanding the law, of empowering themselves, of finding solutions to their own problems, of understanding, the ramifications of the many things that you leave to strangers to decide for you, so that once you have that agency, then you can avoid the pitfalls. Sometimes when I speak like this, the Court Users Committee told me, you may end up taking our jobs from us to the mediators. But I said, this country is big enough for all of us to find space, for us to thrive, to make money in a way that causes the society to live in harmony. So when I speak about justice, when I speak about access to justice, when I speak about protecting people and enabling them to take agency of their own circumstances, I can take the whole day. I wish to stop here so that we can manage time properly and so that we can hear from the other presenters. You'll be told about how to write a will. You'll be told about this mediation and planning and beneficiaries and claimants. Mine was just a general overview of the whole scope of the law of succession and how we access the courts and how we empower ourselves with information, the laws that are applicable, and the procedure that you follow. Thank you very much for listening.
Hello, thank you. Thank you very much. Lady Chief Justice Martha Koome. I've decided. Thank you for that very, very useful presentation. I think we've now heard Section 35, Section 66. I think, and she challenged us about knowledge. I'm sure it's available online. So maybe if we just read into that a little bit, we'll empower ourselves and be better placed. Knowledge is one thing, compliance is the other. What I really love is that our sister referred it to the Bible. And it's so consistent with the Bible. Righteous living, truth, and love would sort out a lot of these things. So we want to give you an opportunity, some 5 minutes. If we can have a roving mic, the mic will be held for you. If you have any questions for Lady Chief Justice Martha Koome. I took advantage, I asked my question. You can see I've got an answer. I'm very firm about what to call her. Any questions, just raise your hand. A microphone will be brought to you. There's a hand here. Let's start here in front. Please just stand up as you ask your question. Please just say your name and then ask your question. So we'll accumulate about 2 or 3 questions and then we'll get an answer.
Thank you very much. My name is Mary Joroge. I worship here at Karura Community Chapel. Chief Justice, I have a question in regard to, you said that you depend on the chief to actually introduce the family to the court. And some of us who live in Nairobi, we don't even know who our chief is or our assistant chief. How is that treated? You know, I felt like we may find ourselves in an awkward position when it comes to such matters that we have to be introduced by the local administrator who is a chief. Thank you.
Thank you for the question. Another question? We are sanitizing the microphone over there.
Thank you also for the opportunity to ask the question.
Can't hear you.
My name is Mary. I'm a student. You said that you've not heard of the case of a man coming after the property of a woman. There is such a case, and I would just like to know what the law states about that. In a case of cohabitation, does the man get the right to inherit the property for a cohabitation of around 3 years?
Thank you. Any other questions? There's a third one at the back. At the back, have you? Yes, please keep your hand up so that we can see you.
Hello, my name is Kirubi. I just want to know what happens in the case where, say, a judgment or ruling is made such that you divide the property of, say, your belated father into, say, 10 people or 10 parts, and the ruling just ends there. I'm not sure how now, as a family, you're supposed to go ahead with that ruling. How now do you divide that into 10 parts? What really happens there?
Did you share your name?
My name is Karen Kirubi.
Thank you. Okay, I think take those ones.
Yes. Who is our chief? I think the way we are structured, we must at least know who is our chief, who is the chairman of our Nyumba Kumi, who is our DO. If I live in Westlands, where is the office of the DO? And once you report there, then they will know how to send an investigator to say somebody lived in Runda, passed away, and left this number of children. Is there a Nyumba Kumi for Runda? There is a structure that can tell you who are the people who lived in house number 41 on Ruakan Drive or wherever. So, because the court really doesn't know, the judge will not be able to know who are the beneficiaries of the deceased unless he had written a will. We have many, many systems of finding out, where was he working. They can also tell us whether he left a list of beneficiaries there at the place of work. The chief will also confirm that. We have many ways of knowing, but what I'm saying is that it's important to know your surrounding when it comes to services of government, the administrative structure of the government, when you will ever need government services. The office of the chief, the DO, is a very important one. And it begins with the Nyumba Kumi, because that's where they will come to find out. This court we are told so and so died from that house. Did he have a wife? Did he have children? Where did they go to school? Some information is gathered like that. And sometimes we get wrong information, but it is later on verified. And the chiefs are aware that it causes them disciplinary action if they give the wrong information. So they go out of their way to bring the correct information because they don't want to lose their jobs. And then Mary asked whether there are husbands who have come to claim property from a woman. I have not seen husbands, as in many, many saying I was a husband. But I've seen these people who come to cohabit with a woman. And now the shoe is on the other side. Because when it started through this patriarchal society where it is the man who owned the property. Such that even if a woman bought property within that cohabitation or within that marriage, they wrote the name of the man. So when I was practicing, because I practiced family law before I became a judge, I defended very many women who had lived in a marriage for many years, and they had contributed to the acquisition of the property. Some of them would tell me that they actually got a loan from their employer, bought the property, but wrote it in the name of the man. And I used to be rude because I was young. I would ask them, and what was wrong with your name? Why would you write the name of a man? A property you have bought with your own money. And they would look at me and say, my daughter, you don't know. We were looking for harmony. They were looking for peace, harmony, tranquility, acceptance. And it went on and on to describe why they registered the property in the name of the man when they bought it. And I understood, because we are a patriarchal society. I've been married to this family. I want to show that I belong 100%. Those who come from Meru, they say when you marry to a place, you go with a guarantee of that years. So how can I be seen to leave that place to spoil the good name of the Merus who go with a guarantee? So if it means me taking a loan and buying the property in the name of the man so that I can conform, so be it. So we had very many cases like those. And it was an uphill task to claim a share of this property when things have gone haywire for this woman who has worked here for 20 years, 30 years, acquiring property, giving birth to children, looking after the man, washing his clothes, including socks, and everything, cooking for him. And then one day she is just told, go. And then she comes to my office crying. I took over these cases because I saw the tragedy in the whole situation. These are women I was looking up as my mentors. I used to see them being driven back left. Now I'm the one being driven back left. But I couldn't imagine a woman who was being driven back left now is going on Kenyan bus. She doesn't even know how to enter a Kenyan bus. She enters before she sits, she is thrown at the back. Then she comes to my office telling me even my back is aching. Now I entered the bus, I was thrown at the back because now I have no car. I took many of those cases. That was my practice. That was my brand name and defender of women's rights. And I defended them vigorously using a very old law, 1882 Married Women's Property Act of England, to show that whatever a woman puts in a marriage should be taken into consideration. And we developed judge-made law precedents to actually show that a woman can get a share. Now we have a whole Matrimonial Properties Act that says what you acquire during matrimony is shared halfway, isn't it? Shared equally. Women, can you say amen to that? So we have come a long way, and women have been empowered from where they could not take a loan, from where they could not buy property. Now they buy properties. And as they buy property, they are acquiring these other people who come to live with them. And now these people are claiming this property. The shoe is on the other side. So as the shoe enters the other side, the man is also coming and saying, I'm entitled to all this property that I found this woman with, or which she bought when we were living together. And they also have legitimate expectation under the Constitution to expect a share. So we have those challenges before us, but what we are saying, let the man say what he was doing to acquire the property. Was he washing clothes for the woman? Was he giving birth to children? Was he cooking? What was he doing? Which can be made into monetary terms. And I think there's a decision we made, although I should not discuss it, that I said, look, if the man was just lying on the couch changing TV channels, is he entitled? But if he was a good man who was really supportive of the wife, loving her, caring for her, encouraging her, supporting her in all ways, then he is entitled, isn't he? So we said it is the same. We will use the same skills, but he has to prove his contribution. We call it indirect contribution. So those cases are coming, they are building up, but people are now more empowered, they are more informed about their rights, they are claiming their rights. Thank you very much. And then there was Madam Kirubi who asked, when judgment is given and said, share property 10 of you, and it ends there, what you're supposed to do, if you can't agree on how it should be shared among the 10 of you, do evaluation of the estate. Find out the value. If it is a value that you can read to subdivisions, and then you can now allocate each person according to the value. If it is a valuation, it's one asset which all of you then can own and then rent and use the income. Or sell it and share the value of the asset equally among the 10 of you. So this is what I'm saying. People need to take charge of their own lives because you've gone to court, it's saying to share equally, and they have closed the file. So it's up to you now to move to the next step. Please, let's value this property. Let us get the value and share the property equally. Thank you very much for those questions.
Thank you very much, Lady Chief Justice. Let's appreciate her one more time. Now you've heard it, Nendeni Mutafute Chief. We'd like to just acknowledge and appreciate Martha for what she's done, is doing, and what we really look forward to her doing for us in future. So, if you'll accept a gift from us, from Hekima, just an appreciation. Thank you very much. Right, I'd just like to make a few notes. I noticed that there are quite a few visitors to Karura Community Chapel, people who haven't been here before. In our Sunday service, we usually welcome you in a big way, ask you to just raise your hand and be acknowledged. But I think it's important that you do know where the restrooms are. The geography of this place, one option is to go out this exit and turn to your right, and you'll find ladies and gents. The other one is to go out the back and turn to your right to keep going until you see the restrooms. They are signposted. You notice we're observing COVID protocols, social distancing. Please keep your masks on, and sanitizing points are available as well. I also see floating sanitizers. We are going to have one more session, formal presentation up here before we break out. When we break out, I will brief you on how it works. I hope you've all registered for your 2 of 5. You have a choice of 2 from the 5 breakout sessions. If you haven't, please feel free. Get up, go to the back to the registration desk, choose your two topics. They're listed there. And let's be ready for the breakout session shortly. It's my pleasure to welcome our next speaker, Advocate Leah Kigwada. Leah is an alumni of the Georgetown University Leadership and Advocacy for Women in Africa Fellowship Program. She's also an advocate of the High Court of Kenya, as are most of our presenters today. In fact, all of them. Her expertise was in the domestic and international aspects of child and family law, really relevant to the topic of the day. She's also experienced in and enjoys real estate and conveyancing law, and is a facilitator of SDRC accredited mediators. I think you'll have to correct that. I'm not sure I've said it right. Part of the team that founded the inaugural Law Society of Kenya Child Law Practitioners Committee. As part of that team, Leah has co-convened the Nairobi Children's Court, Bar, and Bench Committee, and is a member of the High Court Family Division Bar Bench Committee. So she's really got experience in these areas of family law. Leah currently teaches real estate, conveyancing law at the Kenya School of Law. She is an adjunct faculty member of Pwani University and served for 6 years at Kenyatta University School of Law. There she taught family law and international human rights courses. That's such a rich knowledge and experience base. Leah, I'd like to welcome you to take us through the next topic of wills.
Thank you so much, Mr. Odor, for that introduction. I think when it's read out, sometimes you wonder whether they're really talking about you. It's really good to be here. I'm honored. I'm honored by the invitation by the Chief Justice to do this keynote. And also, we had a very wonderful time here virtually with the women of this church when we last did the presentation on family law. So I'm very honored to be here. And my initial invitation was by a former classmate called Anne Darwa. I don't know if Anne is here this morning. She's the one who had connected me to your women's ministry, and I would like to honor her. I'll talk to her myself later, but she's a member of your church, and you know, when they say that you should have friends who mention your name when people want something done, I'm very, very grateful for her. I feel at home here at Karura Community Church. I always come here for happy occasions. I was here a few years ago for my sister's wedding, and then I came again a few months later because her husband was one of your pastors, a former youth pastor here, and so we came for his sermon. And also, I go to the Nairobi Chapel, which there's a sisterhood of churches. I dare not say the mother church, so I'll just say I'll say the sisterhood of churches. And so I feel at home here, and I feel very, very honored by the invitation. I want to take us through. I was asked by Mala, and Mala, thank you so much for making me feel welcome. As soon as the invitation was passed, you really welcomed me in and have facilitated my being here this morning. I'm very, very grateful. And Mala asked me to speak about wills, benefits, and challenges. And as I sat listening to Chief Justice Kome, it was, you know, whenever you hear the issues around when there is no will, you feel like you just need to flip that coin and speak about, when you speak about wills, you're flipping the coin. Because what are the benefits are an answer to the problems. So for example, when you say, where is our chief in Nairobi? You know, when there is a will, you don't need the chief's letter. Your children don't have to come from New York and Brussels after you have educated them and they've gone far. And they don't have to come from New York and Brussels to ask, where is the chief in Westlands? If you write a will, you don't need the chief's letter because it does not need introduction. Nobody needs to introduce. You have already introduced your people in your will. You have said, these are my children. So it's not for the chief to say, this is your wife and this is not your wife. This is your husband, this is not your husband. You know, when you write a will, then you eliminate some of those concerns. Concerns about being 10 to 20, 30 years in court. When you do a will, then you sort of mitigate those problems. Even the issue of cohabitation. If you write a will and say, this person that I live with should be considered. Don't kick them out. Don't disregard them. If you write a will, then that question is already answered. If you don't write a will, it is your family who will be saying this person was useless, or this person was useful, this person was a husband or not, or this person was a wife or not. So it really eliminates many of those questions. And so I feel very honored to have the opportunity to give this talk this morning. So we'll talk first and foremost about estate planning generally, and you have a very illustrious panel of lawyers to discuss it. All my seniors, I'm very, very honored to be here with you this morning, and they will break down, they will give the breakdown of the other, they will go into the details. I'll just do a general overview, and I will begin with the biblical basis for estate, planning your estate, because we know that it is appointed for us to go one day. And the biblical basis is even what Chief Justice Kome pointed out. The Bible says a good person leaves an inheritance for their children's children. We also see elaborate estate planning in Numbers and Joshua, saying this should go here, this should go to this person, and this is what should happen to the property. It's also a sign of good stewardship. We are called to be good stewards of the resources that God has given us, and it creates peace. It creates peace. It eliminates all those fights between brothers and sisters and your children saying that their mother is this or that, or their father is this and that. So estate planning is what you do during your lifetime with an eye to facilitating smooth distribution and management of your property after death. And the question is why? Why do it? Why don't we estate plan? Why don't we write wills? Maybe because of social distancing, we no longer do those things of tell your neighbor or ask your neighbor. But you know the reasons that people don't do it. Why don't we do it? But the question I want to flip is to say, why plan your estate? And I know that there will be a breakout session that deals with this specifically. Failure to plan exposes your family to a variety of challenges after you're gone. And we already know these challenges. We've heard about them. We know about estates that stay in court for all those years. Actually, it's true. It's the professionals that make the money because they have to come and help you to decide these disputes. So it avoids fights over distribution of available assets. And then there is a lack of funds in the immediate period after the death for the day-to-day upkeep of the family while you wait for distribution of the estate. And there are also uncertainties over what assets and liabilities make up the estate. I always say it will be very unfortunate. There is money locked in the bank, but there is no food for the children. There is no food for even the people who are coming to mourn. The children don't have school fees, don't have clothes, but there is money in the bank. And we see the banks with their big fat checks. We see their profits announced. because the money is sitting in the bank and it cannot be touched because you did not plan, you did not indicate to your family. And our families may not be perfect. As you think about that question of why we don't write wills or why we don't plan our assets, our families may not be perfect. Maybe you think this person will be greedy, or this person will do this, or this person will do that. But it is better that it is your family that has the advantage of your hard-earned sweat than a bank that is going to declare billions of profits. If you do the analysis of who should benefit, the bank holding the money and making the billions vis-a-vis your family, imperfect family, go with your family, honor your people. They are not perfect, but they are who we have and they are who we got. So there is also uncertainties concerning who are the actual survivors, who are the beneficiaries of the estate of the deceased, who are the children. Children don't have to come to claim and to try and stake and to say, let's exhume for purposes of DNA. These are some of the issues that are resolved and are reduced when you do your estate plan and you plan accordingly. So there's also the issue of preserving the estate. If you write a will and you say, so-and-so is the executor of my will, that person derives the authority from the will. They are able to say, let's do this, let's keep the property. We know that we need to preserve this. The rent should go to the children's school fees and those sorts of things, as opposed to other people benefiting. For example, your tenants not paying the rent until the issue is resolved because so-and-so is claiming the rent and so-and-so is claiming the rent and those sorts of things, so that you don't have those fights. And it helps to not have the property wasted through either the greed of some survivors or their unpreparedness to handle or incompetence to manage it. And this is your hard-earned sweat. You're the one who knows what you went through to get it. You're the one who knows what it took. You're the one who knows who helped you and who did not help you during this process. And so, as the Chief Justice said, take responsibility. Don't leave it to the courts. Because, yes, the law is there and the law is good. But as the Chief Justice said, we have personal baggages. We think about our own situation. When you come to my court and you are the brother, I think about my own brother and what he has done. So you're giving somebody else the power when you could take it. You could take it yourself and resolve these issues up front. So planning helps prepare your family for the period after your death so that the family has funds that it can access for immediate needs. It also helps with the quick identification of your assets so that they don't go to the unclaimed assets authority. I always think, so this property you worked so hard, you sweated. Your people don't know. Your people don't know that you had a life cover. Your people don't know that you had an account somewhere. Your people don't know that you had saved so many millions with your investment group or your chama. All right? Your investment group or your chama hopefully knows your people and can say she was holding 1 million here. Here, have it. Okay? The bank, if they don't get anybody coming, I think it takes about 5-6 years, and they send it to the unclaimed financial assets. And I hear there are millions, billions being held by the unclaimed financial assets, which may be well and good. But again, wait. Your unclaimed financial assets versus your child, who may not be perfect, who may have wronged you, but unclaimed financial assets versus your child. Government versus your child. So for those reasons we have where we think maybe our beneficiaries are like this, our spouses are like this, our people are like that, fine, they are not perfect, but they are our family. They should be the beneficiaries of our sweat, even as the Bible says, vis-a-vis it going to strangers and it going to waste. So there are different ways of estate planning, but my brief today is to talk about a will. It's to talk about wills. What is a will? A will is a record of your wishes and intentions pertaining to what happens to your property when you are gone. And it is inevitable. It is inevitable. We will all go. And so I was happy to hear about the younger people interested. To arm yourself not only with not only with information to help others, but we also, none of us knows when we are going. And sometimes we think we may not have enough to give out. But even your precious phone, I always remember a long time ago when phones just came, because I'm in that age of people who the phones found us. So I was in my 20s, and a friend of mine was it's not funny, but the way it was put is that he was in town, he was pickpocketed, or somebody tripped him and his phone fell, and he said, "My sweet Samsung." That time we did. Now Samsungs are not cool. Those days Samsungs were the coolest. It was about 20 years ago, and he said, "Oh, my sweet Samsung," because his Samsung phone was taken. He was stripped, and somebody was trying to, I don't know if it's pickpocketing, robbing in town. And so even your phone, your precious laptop that you have, those are things you don't want. Once you're gone, it belongs to nobody. So even if you're young, and since none of us knows when it's time to go, and I'm not saying that you're going, and I'm praying that we all have a long, long life of 120 years, as the Old Testament talks about, but it will be those little things that you'll be surprised at who will take them. You don't want them to go to strangers. So it is good to write your will and review it. And one of the things that we worry about is that once I write a will, can I deal with my property as I wish? Can I deal with my property in my lifetime? And the answer is yes. Writing your will does not affect the way in which you, as the maker of the will, deals with the property. You can decide whatever you want to do with it after that. You can sell it. You can charge it to the bank and get some money. You can deal with your property as you wish during your lifetime, including selling that property. And what's going to happen is that at the time, if you pass on, that property is no longer exists. It just no longer exists. So it may inform the way you deal with your property after that, but it does not stop you from dealing with it, because I think we worry that once you've locked it into the will, you can no longer do anything with it, and that is not the position. You can still sell it. You can do whatever it is you want with your will. And also, a will is ambulatory, which means you can make a will today to say, "Oh, I give all." You may have one car. But if you say, "I give all my cars to my daughter Jane," for example, that 10 years from now, when you pass on, 15, 20 years, whenever it is that the Lord calls you home, your cars will go to the person that you put in the will to get your cars, even if you may not have had so many cars, or you may not have had that particular car. So in that way, it means you can write your will even with your ambition, with your dreams, and with the prayers that you're trusting the Lord in terms of what you would like to have in 10, 20, 30 years, and that will still be taken into account. And then lastly, a will is always revocable. You can revoke it at any time, and you can revoke or alter your will at any time as long as you are competent to make the will. As long as you have the capacity, you are of sound mind, you can revoke it. So it's not like the laws of the Medes and the Persians that cannot be changed. So you can write it today, and we advise that every 3 to 5 years, go through it and review it. Do a fresh one, revoke it, or do a fresh one, or do something called a codicil, which is a document that makes amendments, minor amendments to your will. It is witnessed the same way. It is witnessed the same way as a will. So it is revocable. You can change it. It is not that once you lock it in, that is the end of the story. And I think those are some of the fears that make us not write our wills. So the benefits are, as discussed before, the same as for planning. It avoids disputes between dependents over the estate and creates a degree of peace. It helps to avoid the rules of intestacy that are impersonal and may not fit your circumstances. Because when you go under intestacy where there is no will, how that looks like is that the court just looks at the law. The court doesn't know how hard you sweated, who gave you a hard time, who tried to defeat Who tried to defeat your dreams? Who was the stealer of your joy? Which child, or your spouse, who did what? There is a schedule that says so-and-so gets this. Your spouse gets it for life. After that, it goes to the children on the basis of equality, regardless of how much you spent on which child because they were like this or like that. I always remember in our early 20s, my mom and her, we were, I think it was our late teenage. My mom and her siblings had found this verse that talks about stealing from your parents. Do you guys know that verse? Where it says that it is possible. I can't believe I've healed. Because I remember it really was hurtful at the time, but I've healed because I can't remember it. It talks about something about stealing from your parents, stealing your parents' old age. So those children who are stealing your old age, who are stealing your joy, who are causing you so much trouble, if you don't write your will, and I'm not saying discriminate against your children, but I'm saying the law won't care. They won't know the childhood. The law, when you don't write your will, the law won't know which child lived with you when you were unwell. The law won't know the child who paid the deposit on the house that is in your name. The law won't. There is a schedule. Children are children. Your spouse gets a life interest. And that is what the law will. So it is impersonal, okay? And it is not concerned with your personal situation, with your sweat, blood, and tears, with who did what. It is just the lists that the law talks about, and regardless of what happened, that is how it will be distributed. So you can resolve this by writing your will and making remarks and saying, so and so, I have already given you the house in Nyeri. Therefore, I am giving so and so this. I am leaving this for so and so because they helped me. They paid 60% of the purchase price on this. This is why I'm leaving this to them. So that you are in control and you are taking responsibility. Because when you leave it, the law is impersonal and it will not look into the specifics, the circumstances, your personal issues. Because it just looks like people are squabbling and people are saying bad things about each other. It becomes adversarial in a family setup. And you know, when we fight in families, you fight somebody who will always be your sister. You're fighting somebody who, however bad they are, they will always be your brother. So it reduces these conflicts and it helps you avoid the rules of intestacy that are impersonal and that may not fit into your personal circumstances. Something else that when you write a will, vis-a-vis when you don't write a will, is that writing a will allows you to benefit people who are outside your immediate family. You can leave money to the church. You can leave money to a charity that you're very close to. You can leave money to causes, or you can leave property to causes that meant a lot to you. You can leave to a children's home. You see, the will allows you to do that. But when you don't write your will, only your family can benefit. Only the people in the list as listed in the law can benefit. And so therefore, when you don't write a will, then only your family benefits. But if you write a will, you have opportunity to leave some property and to people who are not in your immediate family, the aunts and uncles who you love dearly and who walked through your life or who played a special role in your life. So therefore, it helps you maintain some power over your property even after you are gone. Then you get a chance to soberly distribute your property instead of other people distributing it for you. Third parties with other vested interests. And it also allows you to fully disclose your property, avoiding the Unclaimed Financial Assets Authority yet again. I don't know who works for that authority or who's in charge of it. I hope they don't one day come after me, but I'm always saying don't let it go, because it's a most frustrating thing to think about the billions that are with Unclaimed Financial Assets Authority when families are suffering and when they could be put to good use, when those facilities could be put to good use. And then it gives you some peace of mind. You know that you have left your people, you have taken care of your people, they are not going to fight. You know who is more powerful and is likely to intimidate the others, because they are your people. So you know that so-and-so is a wonderful person, but other people will run roughshod over her, or they will oppress her, or they will shame her into letting go of what it is that you could leave behind. And so therefore it gives you some peace of mind. It also allows you to appoint the person to administer your estate, who is called the executor. So you can appoint an executor, 1 or 2 executors, even 3, and you can say, if so-and-so is not available, let so-and-so do it. And the executor is the person who is going to say, this is what Leah wanted. They are going to stand with your wishes. And they are the ones who are going to help in the distribution of the property as per your will. So you're leaving the person who you know, you trust. You appoint somebody you trust. Somebody who you know knows your heart. Somebody who you know knows your intentions, the things that you value, and they are going to do this work for you. Now, if you don't, the law says who gets appointed. The law doesn't care about your relationship with them. The law doesn't care about what they did or what they did not do or where you're at in life in your relationship. The law just says, this is the people with priority. Okay? So when you write a will, it gives you the opportunity to say that this is the person, because you know, and you tell them in advance, you will be the executor. And you can have that conversation about whether they want to be the executor or not. They don't even have to come and witness the will. They don't have to know what are the contents of your will. The only thing I say in terms of letting your executor know is when you want your will to be read and how you want your body disposed of. Because I think as Kenyans, we don't read the will. We wonder, when shall we know there is a will, but when shall it be read? Shall it be read after the funeral? Shall we wait for the first year anniversary? And then when we open it at the first year anniversary, because it allows you to say who it is that, where it is you want to be, how you want your body disposed of, because the will allows you to do that, we open 1 year later and find you wanted to be buried in Nyahururu or in Kisumu, and we buried you at Langata. So the only thing I say the executor needs to know, you need to tell them that they are the executor of your will, and then you need to tell them when you want the will to be read, and how you want your remains to be dealt with. And so that is what I say that you need to let your executors know. So the will allows you to appoint the person to administer your estate. It allows you to appoint guardians for your children. Who will be the guardian for your children if you go? And this especially is very important for people who are single. It's important for everybody, but if you're single or you're widowed, it's very important that you appoint a guardian for your children. And I'll speak specifically, for example, for single people, because what I've seen happen, and I was in this situation the other day, where a lady passed on, and she had a child, had a child out of wedlock, and there was no father on the birth certificate. Okay? So while they are mourning this lady, she was in her, I think, her early 30s, she had a little girl. A guy shows up and tells her, Dad, I am the father of the child and I have come for this child. So the father says, what? I mean, I know there must have been a man out there who had this child with my daughter, but she never told us who was the father. You never married her. You never came. The child is 6, 7 years old. We've never heard of you. How do we know you're the father? What if another father now comes? You know, and so there was a whole custody dispute, actually. We had to go to court, we had to do DNA, because the grandfather of the child, who was the father of the girl who passed on, could not just release this child. He could not say, okay, fine, you've come and claimed father. This is a child he had been bringing up. He had been supporting his daughter to bring up this child. Now, if there had been a will, she would have set out in the will and said that if I pass on, the person to take care, my father should take over the care of my child. If I pass on, my sister should take care of the care of my child. Because actually the Children Act says the legal guardian of the child is appointed by will or by court to take care of the child together with the father of the child. So the child is not going to be taken out of the family. Okay, there may be a father somewhere, but then his role will be defined. He may not have priority over whomever you have appointed in your will. So it allows you to appoint a guardian for your child, and it also allows you to give directions on how your body is to be disposed. Now, a body is not property, but your wishes will be honored as long as they are practical. And we've seen this. We've seen burial disputes. And you are stuck in the morgue, or you are stuck and your people are fighting because everybody wants to do right by you. But they don't know what is right by you. Or maybe they don't know maybe you didn't care. And yes, there's an aspect of property tied to that, but you can resolve it up front by just saying where you want to be buried, how you want your body to be disposed. Okay, so these are the benefits. Now I'll spend a few minutes talking about the possible challenges, because I think that's what we worry about. So many people tell me, I don't want to write a will because it will be challenged. I don't want to write a will because it can be challenged. I think that's the issue with many of us. We say we don't want to write a will because we are afraid it will be challenged. And I want to say that challenges can be brought, but many do not succeed. They don't have to succeed. Just because the will has been challenged does not mean that challenge will succeed. So, because I know that's what, and it's a very intellectual answer, isn't it? Because the others are maybe unintellectual. I'm not about to die. I don't really have there are others. But when somebody tells you it can be challenged, that's an intellectual answer, isn't it? It's, it's solid. But I want to say that your will can be challenged, but not all challenges succeed. And many times the challenges do not succeed. And one of the key challenges that comes up is on the issue of capacity. Did you have capacity to write your will? And so what is capacity to write a will? Capacity is you have to be an adult of sound mind to write your will. You know what you're doing. You know the extent of your property and the people to whom you have obligations, such as your dependents. So Section 5.3 of the Law of Succession Act creates the presumption that a person making a will is of sound mind unless the contrary is proved. And the duty to prove that you are not of sound mind is on the person alleging. It's not for me to just come and say, she was not of sound mind, and that's the end of the story. That's not how it works. Is that you have to bring proof that the person was not of sound mind. And one of the things that people talk about is not just the issue of sound mind, but going to the next place where one of the challenges is that the person was having insane delusions. You were insane, and therefore you were deluded about what you were doing when you were writing a will. But interestingly, and this is where I say the challenge may not always succeed, is that even if you are struggling with your mental health at the time of writing your will, it will not necessarily be fatal to your will. it will not be that the whole will, it will not make the whole will invalid as long as your understanding is not impaired. And also, we know that when you're struggling with mental health, you have seasons when you're fine and seasons when you're not fine. So if it can be shown that you are having a lucid moment, you are fine at the point of making your will, then the person challenging your mental status, your capacity at that time, will not succeed in having the will collapse. Okay? So it will only, your mental health problem will affect the will if it shows that it affected the way you disposed of your property. So there must be a connection between your will and your mental health struggle, okay? And that it poisoned the way you did it. But if you wrote your will, even with your struggle, if you are depressed or whatever it is that you are going through, but if you wrote your will and it shows that you are still, it did not affect, that struggle did not affect the way you wrote your will, it did not affect how you did it, then it will not make the will to be considered to be revoked. So it will still stand, because I think those are some of the challenges that we struggle with. So in a case called Banks versus Goodfellow, we lawyers love our cases. And when you teach non-lawyers, because I've taught non-lawyers, this is when they roll their eyes and zone out on you. But we lawyers love our cases. So indulge us just for 1 minute to talk about our cases, because I know that's what, when I've taught in university, I tried to teach a non-lawyers class in university, and I could tell when it came to the cases, they would just want to throw shoes at me. But there's a case that we talk about a lot in cases involving wills called Banks versus Goodfellow. The court held that the will was valid even if the testator believed that evil spirits were chasing him, because the delusions did not affect the way he disposed the property. Okay? So this person believed the evil spirits were chasing. But he did not give the property to the evil spirits. He did not say the evil spirits have told him. It did not affect. So you can see that was a person who was struggling with their mental health, with an insane delusion of evil spirits chasing him. But it did not affect the way he disposed of his property, and so his will was upheld. So what is the challenge that you're worried about? If the person who was being chased by evil spirits in Banks versus stood, how much more will your will stand? So don't worry so much about the fact that your will will be challenged. Okay? So also a will can be invalidated by showing there was fraud, or there was coercion, you were forced, or there was forgery. Okay? Your signature was forged, for example. But even in this claim, because people can claim anything. Anybody can claim if you distributed in the way that they didn't want. They can come and say there was fraud, there was coercion, there was forgery. But even then, it is the person claiming that must prove. Remember, for example, that fraud is a criminal offense. So the standard for proving fraud is a higher standard than just claiming there was fraud. And it is the person who is claiming that there was fraud or forgery, or that you were forced. This is the person who must prove. And the burden of proof is high, because fraud especially and forgery to show that there was fraud, or there was coercion, or there was forgery. So some of the things to avoid. I'll finish off with what to avoid. I'll not go into the creation of a valid will, because that will be handled by my senior and my friend, Tony Njuguna. The things to avoid that may raise suspicion when you're doing your will is avoid having the person helping you write the will be the substantial beneficiary. Don't come to Kigwatha and Company Advocates and give Leah Kigwatha your house. That will collapse. You see, those are some of the things that you need to avoid. Okay? The person who is the holder of the will, the one who is bringing the will and saying, this is the will, making that person also the substantial beneficiary, getting almost everything, that will also create suspicion around your will. Also, suggesting the terms, the person who is the main beneficiary suggesting put this and put that. If that can be shown, there is one case where we study where it says that this was an old, frail person, and he was being forced to write the will and being told he must write this and he must do it. Those are some of the things to avoid. So to avoid that, do it while you're still in good health. Do it as soon as you possibly can. You will have an opportunity to change it, and the will only takes effect when you pass on. If your family finds your will today, even if somebody finds out what it is that you wrote in your will, they can't force you to transfer it at this point. They can't start using it as their own. A will only takes effect upon your death. And so then one last thing to think about is your witnesses, because you will need witnesses. Don't have your witnesses be the same people you are giving the property. Get independent witnesses. So many lawyers in this congregation. Go to their offices. Your lawyer will be one witness. They'll provide somebody else to be a witness, or a friend may be a witness. Let not the witness be the person who is also benefiting, because they'll have to come and say that she gave me everything, and they are the witness. So those are some of the things to avoid, as it creates a strange situation which can make your will to be invalidated. So I hope I've convinced you to write your will. I'll just ask that we skip right to the last slide. What's stopping you? Keep calm and write your will. Thank you very much.
Thank you. Thank you very much, Leah. Before you leave, I'd like to present you with something. So we appreciate that. This is the how. We've been now told the how. From here, we're going to break out into groups. I will briefly introduce by asking them to stand up your respective presenters and tell you how we'll proceed. But in the meantime, I'd like to just say thank you very much. Do accept a gift from us and come back. Not just for a wedding, but just join us. So there you have it. If you have written a will, I've written a will, and it's challenged, quote, Banks and Goodfellow. Banks and Goodfellow, remember that. All right, this is how we're going to proceed. First and foremost, apologies to those who are online. I didn't recognize your presence where you are, but I hope that session and the two presentations have been a good benefit to you who are at home. The online session streaming ends here as we go to our breakouts and to our tea break. Those who are not registered, as you go for your tea break, please go to the back and register for 2 of the 5 sessions. We will have 2 sessions. Each of them will last some 15 minutes, and then you will swap to your second session. Our 5 sessions are as follows. The first one will be on requirements for writing wills. And that will be hosted by Advocate Tony Njuguna. If you just stand up, please. A lot of us know him already. That's Tony Njuguna. He'll be taking the session on requirements for writing wills, and he will be stationed at the back on my left, which is to your right. But as you're going out, on the left. The second session will be the rights of surviving spouses. This will be hosted by Advocate Njeri Karaoke. Advocate Njeri, if you would just stand up, please. She's at the back there, waving. And the session on the rights of surviving spouses will be hosted in the middle on my right. By the way, they're labeled, so if you get lost. The third session will be mediation versus court processes. And this will be hosted by Jane Mwangi. Jane Mwangi, there you are. And Jane Mwangi, will be here on my left to the front. And then finally, we have one of the Mr. and Mrs. duo, which is Rosemary Muhoro. She'll be hosting pre-death planning, and that's Rosemary Muhoro. And her sessions will be at the back on my right. And finally, Muhoro Kimani will talk about beneficiaries and claimants, and his sessions will be here in the front on my right. So we'll break for tea. They will introduce themselves to their sessions, both the first and the second session. I had an elaborate introduction that was going to embarrass you all, but time will not allow. And we'll have tea at the back. As you go out, tea is set out on your right. And what we'd like to ask you to do is get your tea, find your spot, settle down, and see if you can have your tea while there. Okay, I think it's a packed tea arrangement. Yes, so come back to your sessions with your tea, in the interest of time. So thank you very much, Lady Justice Martha Koome, Lady Chief Justice Martha Koome, and Advocate Leah. Thank you very much. We'll get used to it. We'll get used to it. Karibuni. Thank you for the appreciation of our guests. Thank you so much for coming. Karibuni.